All rise. Ladies and gentlemen, the Supreme Court of Alabama, hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Thank you. You may be seated. Welcome to the council and all who are gathered here together. And we are here for one case today. And will, Madam Clerk, please call the docket.
In case number SC 2022-0439, Carol Rogers as administratrix of the estate of Susan Bonner, the Cedar Bluff Volunteer Fire Department and Cherokee County Association of Volunteer Fire Departments. Arguing for the appellant, the Honorable David Bruce. And arguing for the appellees, the Honorable Alan Anderson and the Honorable Britt Monroe.
Well, counsel, good to have you here with us. And Mr. Bruce, you may begin.
Thank you, Mr. Chief Justice. Chief Justice of the Court, it's a pleasure to be here. Certainly glad to have my number called. I know it doesn't happen often, and certainly the first time for me, but may it please the court, my name is David Bruce. I represent Carol Rogers as the administratrix of the estate of Miss Susan Bonner in a wrongful death lawsuit that was filed against the Cherokee County Association of Volunteer Fire Departments, who I will shorten to the association so I don't get tongue-tied throughout this. The Cedar Bluff Volunteer Fire Department, who I will also shorten to the fire department, and Mr. Howard Derek Geis, another defendant whose claims are still pending against him in the trial court. And Mr. Chief Justice, I think I've already arranged this, but I would reserve 5 minutes for rebuttal. And we're here today to ask this court on de novo review to reverse and remand the summary judgment that was granted in favor of the association and the volunteer fire department. We've raised a number of issues in a briefing, but there's really two primary issues this court, we believe, is clear grounds for reversal for this court. First, the trial court committed reversible error in granting summary judgment in favor of the association on the basis that Mr. Geis was not a servant of the association. The evidence in this case established that Geis was a member of the association. The evidence in this case establishes that the association is a nonprofit corporation or organization for purposes of Alabama Code 6-5-336, which is another thing I hope to shorten to just 336 so I don't stumble on that the whole time, if that's okay with you. And more importantly, that Mr. Geis was performing a service in relation to his duties with the association at the time of the incident made the basis of this suit. And under 336E, that's all is required to establish respondeat superior liability, even if Mr. Geis, or there was evidence establishing that Mr. Geis himself were immune under the act. Second, as to the volunteer fire department, the trial court also committed reversible error in granting summary judgment in their favor, and there's dispute of whether the fire department or the town is a proper party defendant. There's kind of dispute whether or not they're a government entity or a nonprofit organization for purposes of 336. This court need not get to that point because if the volunteer fire department was not a governmental entity, then it is liable under 336E just the same as the association is for Geis's negligence, regardless of whether Mr. Geis himself is immune under 336D. If the volunteer fire department or the town is a government entity, and their summary judgment is still due to be reversed because they have not established all essential elements for Mr. Geis to be entitled to immunity under 336D.
Mr. Bruce, I want to stop you and ask you a question. Do you have a Rule 54B problem with this appeal? And I'll tell you, in preparation for today's argument, I went back and read the Lighting Fair case from our court in 2010, written by Justice Lyons, and our court talks about there how a trial court exceeds its discretion when it grants a Rule 54B certification with respect to claims that could become moot depending on the determination of liability below. And when I look at your case, it seems to me if Mr. Geis ends up being held not responsible for Ms. Bonner's death at trial, we may be deciding a moot question here. So I'd like you to address that.
Yes, Justice Mitchell, and that is not something we raised in our briefing. That was a question posed to us, and we are certainly prepared to address that. And we do agree. Obviously, we believe we're entitled to reversal on the merits today, but we do agree that there is a 54B problem, and that this does all become moot if, when we proceed to trial, if Mr. Geis proves that he was not guilty of negligence, or we don't prove that Mr. Geis was guilty of negligence, or that he proves that he was actually immune under the statute himself. This all goes away. And in reviewing the most recent decisions from this court going back to September of 2022, we see, I guess, 5 different cases where this court has dismissed an appeal on the basis of improper 54B certification. I see Erskine versus Guin, Bowling versus U.S. Bank National Association, Million versus Shoemaker, Bentley versus Bentley, and Smith versus Nibco, Inc. And Smith versus Nibco, Inc. Was decided in September of 2022, and I think it shows that 54B certification was actually improper here. 54B certifications are disfavored under the law. They're only supposed to be entered in exceptional cases and should not be routinely entered. And the issue, 54B certification, whether there's reason for just delay, is where the issues in the claim being certified and a claim that will remain pending in the trial court are so closely intertwined, and that separate adjudication would pose an unreasonable risk of inconsistent results.
Mr. Bruce, from your standpoint, we should dismiss your appeal.
That's correct, Your Honor. Again, I think that's the only correct interpretation of the law. Again, I would like to get this resolved on the merits today, but having reviewed the case law as we were ordered to, I do believe that dismissal under 54B, the dismissal is appropriate because of improper 54B certification.
So let me direct your attention to the other defendant. I understand Justice Mitchell's concern and share it. The fire department, though, has immunity defense, right?
Well, both actually moved for summary judgment on the basis that they cannot be vicariously liable for Mr. Geis because he had immunity under 336. 336 only provides immunity for the individual volunteers themselves. If in certain circumstances, if you are a governmental entity, you can be shielded if the servant, if you will, the volunteer himself is immune under the statute. And that comes into play under 336E. Any other entity, nonprofit corporation, nonprofit organization, they don't enjoy that immunity. The 336E provides that upon proof of the negligent act of that volunteer, that's sufficient to establish the respondeat superior liability of the volunteer organization that they are a member of, irrespective of whether the volunteer himself or herself is entitled to immunity under 336D.
Wait, I'm sorry. You're telling me that the Volunteer Services Act, which I understood as an immunity provision, is broadening liability so that you don't have to prove respondeat superior?
Well, they are not entitled to immunities just because the volunteer is entitled to immunity.
Right.
Correct.
For the nonprofit organization and the nonprofit corporation, right?
Correct.
The governmental entity, however, is entitled to that immunity.
Well, they have to establish that immunity under.
Right. They had to show things like good faith that you pointed out in your briefing.
Correct, Justice Scott.
But and then you could possibly get them for wanton conduct if they weren't a municipality.
I would agree with you, Justice Scott.
So back to my basic question. The 54B problem, I see as a serious problem for the vicarious liability defense. On the immunity issue, however, I'm not yet convinced in the 54B problem. Tell me your position on whether the decision in Mr. Geis below would moot the immunity issue.
Thank you, Justice Cook, and I'm actually glad you asked that question, and that kind of runs over into the NIBCO case that I was speaking to. And what's going on here is, the volunteer fire department itself is making an argument that he was not that actually is making arguments that takes Mr. Geis out of the scope of the immunity under 336D. Specifically, whether he was operating within the scope of his official functions and duties with the fire department at the time. They claim he wasn't. Their argument is, oh, he was responding out of jurisdiction, he shouldn't have been on that call. The Cedar Bluff Volunteer Fire Department was not even second up on the roster or anything like that, so they're arguing against it. But the 54B problem still comes into play because, as in the NIBCO case, we have pled wrongful death claims and pled against all three defendants that have combined and concurred to cause Ms. Bonner's death. As a necessary argument, a part of that is they're going to be making arguments that will be counter to one another. We can anticipate that Mr. Geis is going to absolutely argue that it was within the scope of his official functions and duties as a volunteer firefighter, so that he could enjoy that immunity. And that conversely, pits them against one another. You also have two separate other defendants that are up here right now that have made the arguments that they are entitled to immunity. And so, at the end of the day, there's going to be competing evidence. There's going to be piecemeal litigation of this, which I just don't, based on my review of Supreme Court's, this court's case law and recent case law, just can't be resolved in a piecemeal fashion like this. So I do believe that there are 54B concerns that remain, regardless of whether, I guess for any party, they're for all parties.
Let me ask a simpler question. Do you have a case where we determined 54B certification was wrong and the case was about immunity?
I do not.
Yeah.
I'd be happy to go look for that and address that in post-argument briefing if the court would appreciate that, but I do not have a case with me right now.
Yeah. I'm done, yeah.
That is a very good question, and frankly, there's not a fire truck that they respond in. They respond in their personal vehicles. They're all, given that that's what their standard operating guidelines provide for. And if you think, well, there's two ways I see that, and one that has come up in terms of motions they have in terms of being subject to caps and things like that, and I would agree that any judgment against them, I mean, I concede that would be paid out of municipal funds, and that's why we have agreed to dismissal of certain claims on that basis. Here, we have an issue of, we actually named the volunteer fire department itself. It is certified as a volunteer fire department pursuant to the Alabama statute as a separate entity, or separate organization of the municipality itself. And our position is that under 336, that is a specific statutory authority to go after that separate organization. And I'll be candid with you, I'm not aware of any case or from this court or any other court in Alabama that's held that. The other problem is I think they may be stuck with that, and the basis for that is Rule 9 comes into play when you're dealing with lack of capacity to be sued. And they have not alleged in any pleading or pled any affirmative defense that they lack capacity. Now, they've filed some motions where this has come up, and you can see in the briefing how the names have changed throughout the duration of this case. But without Rule 9A specifically requires a particular averment that you lack capacity, It's got to be in a pleading, and a Rule 12 motion for summary judgment is not a pleading under Rule 8. And so they really waived that argument, is our position.
They did give you an interrogatory answer that they were not, that the city, that the fire department had no separate entity other than the city. And they gave you that before you pled your operative complaint, right?
They did say that the volunteer fire department does not exist separate and apart from the city itself.
Before you filed your Second Amendment complaint.
I'll be candid with you. I don't recall those particular dates off the top of my head right now. I have no reason to disagree with you.
And then after they sent you the interrogatory answer, they filed a partial motion to dismiss, raising municipal immunity defenses.
That's correct.
And you conceded to that partial motion to dismiss.
Again, and that's what I was getting to in terms of where the money is paid for, in terms of who is a proper party, who is a organization that can be sued under the statute. I think that's a different analysis. And that's based in large part on the language of 336 itself. Again, I understand there's confusion there. That's why my position is you don't have to get there, because they haven't proven that Mr. Geis is entitled to immunity. So even if they are a governmental entity, this case is still due to be reversed and remanded.
What do you think the standard is for good faith? I ask that because nobody briefed it.
Well, I see my time's run up. I will say very
You
quickly,
may
if I
answer the question.
is I don't know that there is one. All I know is that Mr. Geis testified he did not make a good faith effort to attempt resuscitation with her, and not good faith is not the same as bad faith.
Thank you.
Thank you, Mr. Bruce. Mr. Anderson? And would you please make it clear on whose behalf you're speaking today?
I will make it absolutely clear, Your Honor. My name is Alan Anderson, and I represent the town of Cedar Bluff, Alabama. And I want to begin my time with you by discussing the questions the court posed to the party some weeks ago, and specifically starting with Rule 54B. The court was correct when it properly certified as final its summary judgment in favor of the town of Cedar Bluff on the single wrongful death claim based on negligence still pending against the town, Your Honor, and it certified it properly for two reasons. One, procedurally, it followed Rule 54B. But more importantly than that, and as Justice Cook pointed out, we are dealing here with immunity, but not simply immunity under the Volunteer Services Act. In fact, we are dealing with immunity under both the Volunteer Services Act and 1147-190, which is a statute that insulates municipalities, and only municipalities, such as the town of Cedar Bluff, from willful or wanton or bad faith conduct of its employees or volunteers or agents. And for that reason, Your Honor, it was appropriate to certify, because as this court has said in Ryan v. Hayes, quote, "We repeatedly have stressed the importance of resolving immunity questions at the earliest possible stage," end quote. And that is a 831 Southern 2nd 21. And that's true not simply because the town of Cedar Bluff would be immune. Immunity is great from liability, but also to protect towns and cities and others that are immune from going through the judicial process, going through the trial process, and in this case, perhaps having an outcome that the appellant then later argues somehow prejudices some defense based on a trial that Cedar Bluff doesn't participate in, Your Honor. Now, with respect to the town itself, I want to be clear about this. The parties have always been certain that the party sued here was the town of Cedar Bluff. In fact, as Your Honor pointed out, Cedar Bluff very early on identified itself as a town. Plaintiff didn't object to that interrogatory. In addition, with the operative complaint, Cedar Bluff responded in two ways. It filed an answer that raised numerous affirmative defenses, including 1147-190, which is something only available to municipalities. It filed a motion for partial dismissal, asking that any claims for willfulness, wantonness, bad faith conduct be dismissed at the very beginning. And the court not only granted that motion, Your Honor, the court granted that motion because the plaintiff agreed. The plaintiff consented because it understood that it had sued a town. And in fact, if I'm sitting here correctly, I thought I heard counsel say that payment of any judgment would come out of municipal funds because the plaintiff knows that the plaintiff sued a town. But there's still more than that, Your Honor. As this case went on, there were discovery disputes. The town of Cedar Bluff filed a motion to compel, which ultimately resulted in a resolution between the parties. The plaintiff filed a requested order mooting that motion, and when plaintiff filed that order, plaintiff referred to the town of Cedar Bluff as, quote, the town of Cedar Bluff, end quote. Now, Your Honor, I want to reference a case. It's Wood v. Sentinel Mobile Gathering Systems. It's 189 Southern 2nd 346. It's a 60-year-old case dealing with the interpleader. And this court wrote, quote, jurisdiction attaches to persons, to things, to facts, not to mere words, and an error in name is nothing where there is certainty to the thing. A person may adopt what name he pleases, and if he deals with others or goes to court in a name, no matter what, no harm is done, end quote. It's 189 Southern 2nd 346. Here there was certainty to a thing, whether it was the pleadings, whether it was discovery, whether it was the acknowledgement of counsel, and that certainty is that the town of Cedar Bluff has been sued. Now, Your Honor, with respect to the town of Cedar Bluff, the court properly granted the motion for summary judgment for two reasons. Plaintiff can't make out a prima facie case. Secondly, even if plaintiff could, plaintiff can't overcome the immunity defenses. With respect to the prima facie case, there was no duty or breach of duty by Cedar Bluff. The evidence is that Cedar Bluff was not dispatched to the accident. Cedar Bluff did not dispatch anyone to the accident. Cedar Bluff was not called to assist with the accident because the accident occurred well outside Cedar Bluff jurisdiction. And with respect to Mr. Geist, the volunteer here, he testified, and he is a member of the Cedar Bluff Volunteer Fire Department, a firefighter for the city of Anniston, was also an EMT for DeKalb County EMS. He testified, I responded not in those roles, but as a good Samaritan to, quote, see if I could help, end quote. That's undisputed. There's no dispute about that. Cedar Bluff wasn't there. But, Your Honor, even if Cedar Bluff had been there, this court in the Hollis v. City of Brighton case testified it was not going to hold volunteer firefighters or fire departments like the one we have here to a duty of professional firefighting services. Plaintiff has asked the courts to hold Cedar Bluff liable for a duty akin to professional medical services, professional EMT services, professional paramedic services. That's an expansion that frankly would put volunteer fire departments out of business, and towns like Cedar Bluff certainly would not set their...
Right, but we're not here today on whether
That's right.
that level of professional responsibility was met or not met, right?
That's correct,
That
Your
would
Honor.
come later.
Except in this regard. Plaintiff has to show both a duty and a breach of duty, and plaintiff can't do so here.
Yeah, I wanted to talk about the immunity issue.
Yes, Your Honor.
I thought the plaintiff did a pretty good job of explaining that there are elements to the Volunteer Services Act, and good faith, acting in good faith is one of the elements for the Volunteer Services Act. I did not see that you briefed that at the trial court or briefed it here. Talk to me about what the standard is for good faith and why you've met it.
Sure, Your Honor. And I think the legislature has addressed that in 1147-190. And what 1147-190 says is that a municipality, a town like Cedar Bluff, is immune from liability for wantonness or willfulness or bad faith. Anything that's not...
Part of that. That's why you get out of E, right?
Yes, Your Honor.
Section E. Why is the good faith element met?
Because plaintiff either has to argue that the volunteer acted negligently, in which case the volunteer would be entitled to immunity under the Volunteer Services Act, or the separate claim, because they are not one and the same, that the volunteer acted willfully or wantonly. And while that may be true, or in bad faith, and while that may be true, 1147-190 is what then insulates the municipality.
You're telling me that if someone's alleged to be negligent, they're not alleged to have acted in bad faith?
That is correct, Your Honor. And that's how 1147 reads. 1147 only allows municipalities to be held liable for the negligent conduct of its employees or agents or volunteers, and we filed a Rule 28B supplemental authority, not for violations of good faith, Your Honor. So the court really doesn't need to determine whether or not Mr. Geis acted in bad faith or good faith, because if he's negligent, the Volunteer Services Act applies to the volunteer and to the government for which he volunteers. If he is in bad faith or willful or wanton, 1147-190 provides substantive immunity to the municipality, although it doesn't deny the plaintiff a remedy with respect to Mr. Geis, the volunteer, only.
So you're defining the good faith and volunteer, the good faith requirement in the Volunteer Services Act.
Yeah, what this court has
As
said,
a converse of bad faith in the Immunity Act for municipalities.
that is correct, Your Honor. Now, what I will say, what this court has said about good faith is it is a subjective issue. And here, the testimony from Mr. Geis is that he responded to, quote, "see if I can help." Clearly, the response was made in good faith based on the fact he wanted to see if he could help. Now, whether he was negligent when he got there, that's something they'll have to litigate at trial. Finally, Your Honor, very quickly to wrap up, with respect to what, if anything, this court needs to do, frankly, we don't think anything this court needs to do. It's been certain who the defendant was. But if the court is so inclined, it can follow its brethren in the federal courts or other states and simply amend the caption to call the Cedar Bluff Fire Department what it is, the town of Cedar Bluff.
Mr. Anderson, I need some clarification on
Yes,
one
Your Honor.
thing that you mentioned, outside of their jurisdiction.
Yes, Your
Is the jurisdiction the same as the municipality's law enforcement jurisdiction, which is outside the city boundaries?
That has always been my understanding, Your Honor, but I've not specifically researched that issue with respect to fire departments. What I will say, though, is there's not much dispute this was well outside Cedar Bluff's jurisdiction. And if Cedar Bluff had responded outside of its jurisdiction according to the statute that permits that, it would be presumed to respond as a governmental entity. There are no further questions, Your Honor. We would ask that this court affirm the decision of the lower court below granting summary judgment to the town of Cedar Bluff. Thank you.
Thank you, Mr. Anderson. And Mr. Monroe, same question for you. Would you please clarify who you're speaking on behalf of?
Yes, sir, Mr. Chief Justice. On behalf of the Cherokee County Association of Voluntary Fire Departments. May it please the court, Mr. Chief Justice, Associate Justices, my name is Britt Monroe, and I represent the Appellee, and I'll just call them the association. To give you just a quick factual background, the association was incorporated as a 501c3 not-for-profit. It's got no employees, pays no wages, pays no salaries, provides no employee benefits, has no office, no voluntary fire department, no voluntary firefighters, no fire truck, no fire hoses, no ambulances, no EMTs, doesn't respond to calls, performs no training other than purchasing some training manuals that are used by the various departments, and only has, despite plaintiff's statements or appellate statements in their brief, only has 13 members. Mr. Geis has never been a member and will never be a member because membership requires to be an incorporated voluntary fire department. There are only 13 of those that are members.
Why did you insure him into workers' comp?
Just as many organizations do, Justice Cook, and I think the Alabama Bar is a perfect example of where we are. So the Alabama Bar sits right over here across the street. It's an association. I have to pay dues. I have to be a member. They have ethical guidelines I have to follow. They have opinions that I have to follow. I can get insurance, group insurance for my firm through the Alabama Bar Association. I can get individual health insurance for myself through the Alabama Bar Association. The Alabama Bar Association promulgates rules that I have to follow in CLE. They promulgate rules that I have to follow with respect to how many hours of ethics I have to have. But none of that makes the Alabama Bar responsible for my malpractice if I committed it in here today. And what the plaintiffs are asking you to do, to just cut to the chase here without going through the law, which the trial court appropriately and accurately analyzed these claims as to the association, even though appellant complains about how they got there. But the bottom line is, it is a very slippery slope. It's a slippery slope that's going to apply to the American Automobile Association. It's a slippery slope that's going to apply to the Alabama Medical association. It's a slippery slope that's going to apply to the organization which all accountants in this state have to be in. Every organization that has members, if you were to rule as and find the law as Appellant has asked you to find it, every one of those organizations is now strictly liable for the torts of their members. And there is no way that is what this statute was meant to say. They have been misstating what 336 says. 336 says, if you are a nonprofit and a volunteer of yours, which he is not a volunteer of ours, and that's what the court found. If a volunteer of yours is immune, you cannot, unless you're a governmental entity, step into the shoes of that immunity. The statute does not say if your volunteer creates a negligent act, you are now throwing respondent superior out the window and you are strictly liable for that act. That is not, in the Ex parte Dixon case, makes that distinction on page 336, as the justices noted. What 336 does is it says, hey, we're going to abrogate this small part of the respondent superior rule, which at common law says if the servant is not liable, the master can't be liable. So what we're going to do is, in order to balance the protection of interest between the need for voluntary firefighters, but also the need to protect people that the voluntary firefighters provide service to, we are going to abrogate the master being able to use the defense that the servant is immune and has no liability. That's what it says. And the trial court perfectly looked at this case and got it absolutely right. Judge Taylor looked at this and said, this man's not a volunteer of the association. He didn't perform any services for the association. 336C4 defines what a volunteer is. The volunteer has to be performing services on behalf of the nonprofit. He said, we don't have that here. So now I got to fall back to the common law. And what does the common law tell me about respondent superior? Well, the common law tells me you can have respondent superior in the context of employee-employee. You can have it in the context of agent to principal. And he looked at all of these. And the only one that fit this circumstance was potentially employee, employer, or master-servant, as the cases like to refer to it. And he came to the conclusion, which is the exact right conclusion, that there is absolutely no evidence that Mr. Geis was in any way an employee or a servant of the association. And he couldn't be an employee or a servant of the association. And the only things that appellants rely on to try to cross that and create an issue of fact are, 8 years ago, the federal government gave a grant to the association. The grant was for a radio tower and for radios. One time, association used the money to build the tower or to have someone build the tower, provided the money for the radios to the various fire departments, purchased the radios, who then provided them to their voluntary fire departments. That's not control of how Mr. Geis is performing his activities.
I want to, you've talked about the merits, which are helpful. I want to go back to Justice Mitchell's point. What is your position on whether this was a proper 54B certification?
Your Honor, I think it, Justice Cook, I think it was a proper certification. Now, I certainly understand Justice Mitchell's concerns. My former law professor and Justice C have read the opinion. Actually, it's the appellates that decided to frame this as an immunity issue and bring it to Your Honors. Clearly, the judge did not frame it that way in his order, I agree. But the plaintiffs and all their defenses to the summary judgment framed it as an immunity issue. Also, under Justice C's opinion, it doesn't really matter what happens to Mr. Geis at the bottom, okay? So this isn't a situation where if you send us back and the court determines, and the trial court determines, all right, Mr. Geis is a volunteer and Mr. Geis is immune. That doesn't end the case against the association. Or if he determines that Mr. Geis is not a volunteer, he can't jump through the status and take on the status of 336. He only has the status of an employee. That doesn't end the claims against the association. So while the status of Mr. Geis may be determinative as to the Cedar Bluff, or the town of Cedar Bluff, or the Cedar Bluff Fire Department, I'm not getting their argument whether they're separate and distinct, but whatever name they want to call themselves, yes, it would, but it would not as to the association, Justice.
Mr. Monroe, draw that out for me a little further. You said it would not end the claims against the association if Mr. Geis were found not liable. Did I understand you correctly?
If he was found not liable, yes, sir, it would. But if he was found immune, it would not.
All right, but if he were found not liable, it
Yes,
would
sir.
end the claims.
Well, of course, yes, sir, Justice Mitchell. If he was found not liable, absolutely, nobody could have responded out superior for that. Okay. But the issue before the court on the immunity, how that's determined as Mr. Geis is not determinative as to the association, because either way, whether he's an employee or a servant or a volunteer, he must jump through the hoops of respondent superior to attach liability to the association.
So there was some discussion in the briefs or in the trial record about a dispatch protocol. Is it true that your association creates the dispatch protocol?
No, sir, that is not accurate. If you will look in, Your Honor, I actually was anticipating that question. It's document 372 at page 982 of the court record are the bylaws of the association. That bylaw says, quote, that we will, and I'm just going to read it to you, Justice Cook. I have it right here. Says that one of the reasons for objectives of the association is to draft and submit to Cherokee County E911 Board for approval a dispatch policy for fire members. So what happens is Cherokee County runs its own 911. It's a county-run system. What we did was, along with the other 13 departments, we drafted a set of rules for dispatch to follow in calling out firefighters. We did not have the right to make E911 use those rules. They have to be approved by E911. And you talk about all the rule changes that they talked about in their brief. There are no rule changes because the association has no rules, policies, or procedures. What they're talking about is at times the fire departments get together, have a conversation and say, hey, we ought to tweak this dispatch rule. But they can't tweak that dispatch rule by themselves. They have to submit it to E911 for Cherokee County, who has to approve it, and then it's done. We can make all the, may I finish?
Oh, of course.
We may make all the suggestions we want, Justice Cook, but the ultimate authority to approve that, as set forth in that document, which you will see, all falls with the county and with their run 911 service.
Mr. Monroe, I have one more question I need
Yes, sir,
some
Mr. Chief
clarification on. What does it mean for a member of one of the volunteer fire departments to be on duty?
What does it mean to be on duty?
Yeah.
Your Honor, I don't represent the town. All I can tell you is what I've seen in the record. And it is said in the record that when they have their radio on, that they can be on duty. That they don't have to respond to calls, but if indeed they have their radio on and they hear a call, that they can respond. But, Mr. Chief Justice, we have nothing to do that. We don't do the call out. The only thing we've ever had to do with the radios is we got one federal grant from the federal government one time, almost 9 years ago, to put up one tower and to buy handsets that were delivered to the various fire departments. We didn't give them to individual volunteer fire departments. The fire departments themselves hand them out. And that's the only thing that we have to do with the radios.
You may wrap up your remarks now.
Yes, sir. I will finish by just going back to, I think, which is the most common sense argument, which is the one I talked about for the Bar Association. And it is a slippery slope. If this court is going to find that an association that is essentially put together to allow a group of people to get better rates on their workers' compensation, to dole out tax money, and to dole out federal grants, if those people are going to become liable, those associations, for everything that its members does, that is a slippery slope that I don't think this court has ever considered going down, and I urge this court not to go down it on this point. And I finish up with, Judge Taylor got it right. He read the briefs. He realized there was no volunteer status. He realized that he fell back on common law, respondent superior. He analyzed the facts that there was no employee, agent, or servant responsibility here, and he correctly granted summary judgment. And I urge this honorable court to recognize Justice Taylor was correct legally with his application of the law and facts and affirm his ruling. Thank you for the time, Mr. Chief Justice.
Madam Clerk, while Mr. Bruce is approaching the podium, we went overtime with Mr. Monroe, so allow an equal amount additional time for Mr. Bruce.
I appreciate that, Mr. Chief Justice, but I hope not to need it. I will address a few points from each appellee in kind. First, with the volunteer fire department, they bring up this argument about immunity under 1147-190. That's not an issue here. He's filed that in a letter brief after the fact. That can't be brought up or considered for the first time here on appeal. Even if it was, his point was that by arguing Mr. Geis's testimony that was not acting in good faith means that he was necessarily acting in bad faith, and that's simply a logical fallacy. I think that's pretty apparent before the court. Talked about a prima facie case and duty and breach. The direct negligence claims aren't at issue here. This is immunity under 336. I do want to address one thing that brought up with respect to the status, and this was one of the questions the court posed to us. What can you do? If the court were to determine that the town was the proper party, I would be all for simply just changing the name. I don't know that that is a procedurally popular mechanism under Alabama law. As far as I know, you have to make a change under Rule 15C3, and I think we'd be fine with that here, but that's something I don't think can be done at this level. As to some of the association arguments, argue about there are no volunteer members, direct the court to a number of materials in the record. Page 993, the membership roster is included with this facts. Membership is 236. 995, tell us about your employees. See attached roster for all volunteer members. 1001, Howard Derek Geis is listed as a volunteer member. And the association's own corporate representative agreed that Mr. Geis was a volunteer member of the association. And so when they say there's no evidence of having a volunteer member, that's just incorrect, and that's belied by what the record is before the court. I appreciate that question, and that's exactly where I was at, Justice Sellers, because it's not an accurate statement. One thing under this statute, Section A, or Section B, pardon me, is the legislative finding of what this policy is. And the policy behind 336 is to encourage more volunteers. And the bargain for that is to have these organizations be responsible for the volunteers if they commit acts of negligence like is present here. This is not some slippery slope. That's going to apply to a wide range of anybody that is a member of the State Bar Association. I think that's a false analogy. You're talking about the association, the Cherokee County Association. If a volunteer is acting within performing duties on behalf of that association, sure. I mean, it's just the same way as an employee is driving a car, a truck on behalf of the truck driver he works for. I mean, I don't think that's any different. But this is a specific finding under Alabama law of them trying to encourage, the state legislature trying to encourage more volunteer participation. And that's why that's kind of the benefit of the bargain, is to shift that responsibility off the individual to the individual organizations that they're volunteering for. And it's not just a gross slippery slope, like he says. And it only applies in, I think, a very narrow field. It's not just to be a part of a bar association or anything like that. Right. And that's the very definition of volunteer under Section C4. Person performing services for the nonprofit organization other than without compensation other than reimbursement for actual expenses incurred. That's what the law says. which responding to calls and motor vehicle accidents and emergency medical calls is what the association's own representative said is what they're precisely supposed to do in Cherokee County. And so that's my clear reason why summary judgment was improper and properly reversed. And that's what we're here to request today, on behalf of the summary judgment granted in favor of both appellees be reversed or remanded. I think the justices have brought up, and we've talked at a great deal of length, that the 54B problems with that, and I would, to be candid, I don't know that this court, I think the court doesn't have jurisdiction to do that. If the court disagrees, then I'd be happy for you to reverse and remand it. That's what we're here to ask for. I just don't think you have jurisdiction to do that under 54B. The case law that's from this court, especially the recent case law and the NIBCO case and the four others that I named to you earlier. Well, they've argued against the application of immunity to Mr. Geis under the statute. Again, the statute does not provide immunity to the bodies, the volunteer organizations themselves. It only provides immunity for the individual volunteer member. Now, if the individual member is a governmental entity, I'll concede that they're potentially, if the volunteer member is subject to immunity under the statute 336D, then that governmental entity is shielded. That doesn't work. That's not the case if it's a nonprofit organization or a nonprofit corporation. I'm on yellow. I'd be happy to address any other questions I have in the limited time I have left with you.
Looks like
Thank
no
you.
further questions, so you may give us a concluding statement.
Thank you for your time.
Well, our thanks to the council for both parties, and we will take this under advisement. And with that, we now stand adjourned.
All rise. The court is adjourned.